Police of the Metropolis.
And before we begin, just to remind everybody that there is an anonymity order in this case, that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant or any member of her family in connection with these proceedings. I understand that you're both content with that order.
My lady, I'm grateful. Thank you.
Very much.
Thank you, my lady, my lords. I appear with Mr. Kemp on behalf of the appellant. Mr. Linden, Queen's Counsel, appears with Mr. Crozier for the respondent, and Mr. Bowen, Queen's Counsel, appears for the Equality and Human Rights Commission, the HRC, as intervener. Your ladyship and your lordships will also have noticed that you have a written intervention submitted on behalf of a number of NGOs, drawing attention in particular to the importance of the issues raised by this appeal on black and ethnic minority police officers and other professionals too. Before I open, my lady and my lords, you should have two new volumes of authorities, volume 16, prepared by the appellant, and volume 17. Volume 16 comes in electronic form as well, with a searchable page numbers, I'm told. Volume 17 is in hard copy only, and if it didn't arrive yesterday, then it certainly would have this morning. Oh, and I beg your pardon, it's also in electronic form.
We've got it in electronic form, have we?
I'm told by Mr. Linden that you do.
Well, I don't
Right.
at the moment, but no doubt it will come.
Well, there seem to be two memory sticks on my...
I've only got one.
The one in the little packet, the one in the white packet is volume 16, because that was prepared by Oye, so it's in the normal form. The one that you're holding, my lady, looks like it might say Matrix on it. No? Okay, it looks like a Matrix USB stick.
It says,
Whatever that means.
Anyway,
Anyway, we
blue
do have
is
to-
17.
yes, is that this will be 17.
Blue is 17, white packet is 16. You also have hard copies. If there's any difficulties, then we will endeavour to sort those out over the lunch break so that your ladyships and your lordships can be sure you have it in both formats. My lady then, as your ladyship and your lordships will have seen, this appeal raises the question whether a police misconduct panel, which as I'll come to, performs the function of hearing and determining misconduct allegations against police officers, and in the case of non-senior police officers, dismissing them, where said to be justified, whether they attract judicial proceedings immunity. If at common law, the position is that such a panel does attract such immunity, the question then arises whether in claims under Part 5 of the Equality Act, addressing discrimination in the sphere of work, displaces that immunity by reason of the operation of the Equality Act itself, EU and convention law. It's the appellant's primary submission that the panel is not a judicial body at common law. It does not, therefore, attract judicial proceedings immunity. And in any event, the appellant has a right, in common with other police officers, under primary legislation, the Equality Act, to bring claims of discrimination under it in respect of her dismissal, consistent with the rights conferred by EU law, and any impediment to the exercise of those rights in the form of a common law immunity would violate her right to access a court under Article 6 of the Convention and Article 47 of the EU Charter, and violate her right to an effective remedy under the equality directives, which I'll come to in one moment. The background to the appellant's claim is set out in the SFI, and I can deal with it very shortly indeed. You will have seen that the appellant was made subject to misconduct allegations following an incident outside of work. Those allegations of misconduct were in due course referred to a misconduct hearing under a scheme which I'll take you to in one moment. The panel determined that the appellant had committed acts of gross misconduct, and the panel dismissed her without notice. It's necessary, my lady and my lords, to look at only one contemporaneous document in relation to this. And if I can ask, please, that the core volume is turned up. Part 1, MS 512, core volume, Part 1, MS 5152.
5152.
5152, sorry, my lady. You have that, my lady? 5152, and this is the decision of the misconduct hearing. And you'll see, first of all, at 5152, how the hearing or the panel was constituted. Commander Julian Bennett, so a police officer, senior police officer, Superintendent Stuart Palmer, again a police officer, and Ms. Anita Prem, independent member of MOPAC. MOPAC is the Mayor's Office for Policing and Crime, and it is now the relevant police authority, that is the police authority for the Met Police. And we can take it
now rather than then.
Then as well.
Then as well.
So we can see MOPAC referred to next to as Anita Prem, independent member, MOPAC.
Yep.
We can assume, as I'll come to in one moment, that she was the human resources person. We'll see how that is in one moment when we come to the regulations. But in any event, the MOPAC person and 2 police officers, there is a account of the facts as they find them and their conclusions given thereafter. And importantly for our purposes, at 5156, having found gross misconduct, in the box at the top, the second paragraph, we have fully considered all of the available outcomes, and we're of the view that the mitigation does not outweigh the negative impact and damage to public confidence as a result of her conduct. Accordingly, the appellant will be dismissed from the MPS without notice. It is the panel that imposes the sanction of dismissal. And we'll see that when we come to the regulations in one moment. As to the claims that have led finally to this hearing, keeping open the core volume, the claimant brought a claim thereafter in the Employment Tribunal alleging disability discrimination. I needn't take you to the originating application, that's the claim form, but if I can take you to the further and better particulars, which ultimately contained all the essential elements of her claim. They're at 5172, 5172. And the relevant pleading begins at 5180, pleaded claims, 5180. And at paragraph 25, the claimant complains that in subjecting her to disciplinary proceedings for gross misconduct and in determining to dismiss her, in particular notwithstanding the medical evidence available to the respondent concerning her disability, she suffered continuing discrimination. And then moving down to A, there's a complaint of discrimination arising from disability under section 15. Little b, a failure to make reasonable adjustments, contrary to section 20 and 21. And then at little c, harassment, contrary to section 26. So she makes complaints in particular in relation to the decision to dismiss her, relying on the relevant parts of the Equality Act 2010. Her claims were struck out by the Employment Tribunal. Don't need to take you to that decision, but for your note, it's at memory stick 5143, the same part of the core volume. Struck out on the basis that the panel enjoyed immunity from suit as a judicial body. It isn't necessary to study that decision because the Employment Tribunal simply followed the Court of Appeal's decision in Heath, which I shall have to take your ladyship and your lordships to in one moment. The same is true for the Employment Appeal Tribunal and indeed the Court of Appeal, though I will make some observations about the Court of Appeal's decision as I develop the arguments before your ladyship and your lordship. Before I come to the regulations which govern the misconduct panel hearing, I propose to take you to the Equality Act so that your ladyship and your lordships can see how the conduct of the misconduct panel fit into the scheme of the Act. So the Equality Act, you'll find at Volume 1 of the Authorities, Tab 2, MS 107. MS 107. Starting then, please, with the concepts of discrimination, which I will deal with very quickly. Section 15 you'll find at MS 108. No issues turn on this, so it's just to contextualise the claim. MS page 108, section 15 deals with discrimination arising from disability. Person discriminates against a disabled person. They're treated unfavourably because of something arising in consequence of disability, and it can't be shown that the treatment is a proportionate means of achieving a legitimate aim. Over the page at 110, MS 110, section 20, imposes a duty to make adjustments on those caught by the terms of the Act. And section 21B makes it discriminatory for a person to fail to comply with that duty. So A discriminates against a person if A fails to comply with that duty in relation to that person. So another form of discrimination. And finally, on the protected or the prohibited conduct, as it's known, prohibited conduct, harassment is dealt with at page 113, MS 113, section 26. A person harasses another if they engage in unwanted conduct related to a relevant protected characteristic, and so on. There are further particulars of the concept of harassment. But those were the forms of prohibited conduct relied on by the appellant. Then at section 39, the relevant unlawful act is set out. That's MS page 115, section 39. Your ladyship and your lordships will see that this part of the Act is headed up Part 5. That's material, as I will come to, given the way the respondent puts their case now. Part 5, work, Section 39(2). An employer must not discriminate against an employee of A's, that's the employers, B, as to little c, by dismissing B, the employee, or little d, subjecting the employee to any other detriment. Now, as your lordships and your ladyship, of course, well know, police officers are not employees, so special provision is made in relation to employees. That's seen at section 42. In fact, before I come to that, I should just bottom out harassment. So MS page 116, I just took you to the prohibitions on discrimination in the context of work. And MS 116, section 40, outlaws harassment in the context of work. So your ladyship and your lordships have seen defined the concept of harassment under section 26. And section 40 makes it unlawful in the sphere of work. An employer must not, in relation to employment by A, harass a person who is an employee of A's. Little 2 to 4, 42 to 4, you can put a line through because they've been repealed. But section 41 creates the relevant unlawful act for the purposes of harassment. As I was about to say, of course, police officers aren't employees, so special provision is made. That's made at section 42 of the Act. Section 42, for the purposes of this part, that is part 5, one can deduce only for the purposes of this part. Holding the office of constable is to be treated as employment by the chief officer in respect of any act done by the chief officer. Pausing there, in this case, that's the Metropolitan Police Commissioner. Or, so the chief officer in relation to a constable or appointment to the office of constable, or by the responsible authority, that's MOPAC, Mayor's Office for Policing and Crime, in respect of any act done by the authority in relation to a constable or appointment to the office of constable. So Section 42 creates a notional employment relationship so that a police officer can benefit from the protections afforded by Section 39.
Can I ask Ms Monaghan, the respondent in his written case raises a point that, as he argues, the dismissal that we're dealing with here wasn't an act done by the chief officer. So far as I can see, that point wasn't raised below. Am I wrong about that?
It wasn't raised below. It wasn't raised in the notice of objection to the appellant's notice of appeal. It wasn't raised in the SFI, which is why it's not dealt with in our case. The case so far has proceeded on the basis that but for the judicial immunity point, the appellant would have a claim. Indeed, if she wouldn't have a claim in any event, that's a complete answer to these proceedings. One wouldn't be here dealing with judicial immunity. I shall have to deal briefly with the point in any event because it is there, and I'm not going to be thanked by anybody for saying it shouldn't be dealt with. But you'll see that Section 42 then deals with, creates a notional employment relationship for the purposes of ensuring that a police officer enjoys protections against discrimination at work. As I've indicated, the Section 42 provision applies apparently only for the purposes of Part 5. There is a vicarious liability provision in the Act, which I'll have to take you to. That is in a different part of the Act, Part 8. And so it has been argued in earlier cases that there is no vicarious liability attaching in the case of police officers, so that only acts done by chief officers fall within the scope of Section 39. So in other words, a chief officer, I haven't expressed that terribly well, I'm sorry. A chief officer, it's said, and is said by the respondents now, is not to be treated as vicariously liable for the acts of his officers, because it is only the acts of the chief officer that are caught by Section 42, and there is no vicarious liability provision in Part 5, and the construction of an employment relationship applies exclusively to Part 5. I'm not sure if I've expressed that. Is that clear enough?
Where's the vicarious liability provision?
Vicarious liability, may I just finish this one? No, not at all. I will take you to it, but I want to take you to how we've got to this point. That is how Section 42 is in the frame at all. Early case law said, as I've indicated, that because of that, there's no vicarious liability and only acts done by chief officers are caught. As I will have to come to, the effect of that was amending legislation was introduced in the predecessor legislation, Race Relations Act, Sex Discrimination Act, and so on, to fill that apparent lacuna.
Can I just pause there? I invite my learned friend to pause there. I think we may be, Ms Monaghan may think we're running a point that we're not running, so it may be helpful if I indicate our position. It may save time.
Certainly, please do.
I think Ms Monaghan thinks that we're arguing that Section 109 does not, even in principle, apply to Section 42. So Section 109 is the vicarious liability provisions. and that we're trying to revive an argument that found favour with the Court of Appeal in the case called Liversidge, which you may have seen referred to in our case. We're not running that.
So you're not arguing that Section 109 doesn't apply?
We're not arguing that it
The
can't
appellate
apply.
situation.
We accept that Section 109 is in principle applicable to Section 42. What we submit is that on its true construction, Section 109 does not assist the appellant in this case, because the members of the panel are not agents of the chief officer when they make their decision, and nor are they employees. So it's a narrow argument that I think we're being...
They're not acting as police officers now.
Exactly, they're discharging their statutory functions under the statutory instrument. I don't know if that helps. It was intended to.
Section 109 has a potential application in a different context to Section 42.
That's right.
Yeah.
Well, I
I'm
better...
not, in other words, I'm not saying, Section 109 doesn't apply to Part 5, which
So it could apply, for example, if a superintendent disciplined or did something in the police station to the police constable.
it could apply, for example, if a constable was being harassed by her colleagues at work.
Or if her superiors behaved in such a way as to amount to constructive dismissal.
That type of
It
situation.
could apply to that, but it doesn't apply to them when they're acting qua members of a disciplinary panel.
Exactly.
That's your argument.
Well, that's a much simpler argument, and I can delete a number of pages of my notes. Before I just come to that, yes, I can delete a number of
This
pages
is the
of my
sort
notes.
of problem that arises if people start introducing new points at this stage in proceedings.
Precisely. I mean, as you can see, the respondent's case is largely premised on the argument that for Article 6 purposes, for example, there isn't a civil right at all engaged because there's no right under the Equality Act at all, as well as, and therefore not under Article 47, etc. It does make it very difficult to address that in circumstances where there isn't any case that we've been able to answer at an earlier stage. But let me take your ladyship and your lordships to Section 109, and if I have to come back to this in reply, then I trust your ladyship and your lordships will forgive me, but it may become clearer in due course. Section 109 is MS 137. Anything done by a person in the course of A's employment must be treated as done by the employer, so vicarious liability. And 2, anything done by an agent for a principal must be treated as also done by the principal. So covering both agency and employment, creating vicarious liability, and conferring liability on a principal, that must apply to Section 39. I think it's accepted that it applies to Section 39, since for the purposes of Section 39, there is an employment relationship. Section 39 deals in terms with dismissals. I won't trouble you with the way in which this argument had developed prior to the Equality Act, because it seems to be accepted that whatever earlier case law has said, this is the position we've now reached. So prohibition on discriminatory dismissals and vicarious liability where that dismissal is affected by a constable, we say. And in this case, we have 2 constables on the misconduct panel, as well as a member of MOPAC, and of course an agency relationship may attach there, but in any event, given that a decision can be taken by a majority, it won't answer the question in this case. Section 109, I need to take you briefly to the directives, because there is no doubt in our submission that as a matter of EU law, the appellant enjoys the right not to be subject to a discriminatory dismissal in the context of her the holding of her office as a police constable. If I can ask your lordships please to go, and your ladyship to go to volume 1, tab 13 MS 3112, tab 13, MS 3112. This is the race directive. As the title says, it's the directive that implements the principle of equal treatment between persons irrespective of racial or ethnic origin. It contains a number of provisions. 314 covers scope.
Are you, yes, did you say 12? Oh, 13, sorry.
13, we're dealing with the race directive. It's not
Yes.
centrally an issue here, but it's
Forgive me.
it's part of a package of equality directives that apply to police officers as well as, so apply in the context of this
Thank you,
case.
yeah.
Although this,
It's the one for disability.
there is one for disability. I'm just flagging them all because there is a package of equality directives, all of which require member states to enact legislation outlawing discrimination within the field of work, amongst other things, and which are directly effective against, of course, an emanation of the state. So MS 314, at Article 2, we see the concepts of discrimination. 3, scope, covers employment. And scope 31C covers dismissals. And so I don't have to come back to this when I deal with the impact of EU law later on. Article 7 deals with the issue of judicial control. So Article 7.1, which is MS 315, member states shall ensure that judicial and or administrative procedures, including where they deem it appropriate, conciliation procedures for the enforcement of obligations under this directive are available to all persons who consider themselves wronged by a failure to comply with the principle of equal treatment. And then at 15, provision requiring member states to lay down rules on sanctions applicable to infringements, which may comprise compensation to the victim, which must be effective, proportionate and dissuasive. The directive we're concerned with, going back one but forward in time, is at 305 tab 12, so back one but forward in time. This is Council Directive 2078 EC. Deals with establishing a general framework for equal treatment in employment and occupation, and this is the directive that addresses disability discrimination. And so we see at Article 1, the purpose of this directive is to lay down, which is MS 307, Article 1, MS 307. The purpose of this directive is to lay down a general framework for combating discrimination on the grounds of religion or belief, disability, age or sexual orientation, as regards employment and occupation, with a view to putting into effect in the member states the principle of equal treatment. It defines at Article 2 the concepts of discrimination, which reflect those seen, unsurprisingly now, under the Equality Act. Article 3 deals with scope. As with the race directive, under 3.1c, it covers dismissals. Unlike the race directive, there is a specific provision addressing disability in the context of certain occupational work. So Article 3.4, bottom of MS 308, member states may provide that this directive, insofar as it relates to discrimination on the grounds of disability and age, shall not apply to the armed forces. It's the only directive that makes that exception. Doesn't contain an exception in relation to policing, although I ought to draw the court's attention to recital 18, which is at MS page 306.
I suppose in some countries, the police may be regarded as armed forces. But anyway, it doesn't apply here because we've got Section 42.
We've got Section 42, but for completeness, since I drew your attention to the exemption in particular in relation to armed forces, Recital 18 makes it clear that the directive doesn't require armed forces, police, etc., to recruit or maintain a person who doesn't have the required capacity. That in any event might be deduced by the various qualifications to the concepts of discrimination. But in any event, there's no general exemption where a person is employed, and certainly none within the substantive provisions under the directive. As with the race directive, there's provision addressing judicial control at Article 9, MS 309, and sanctions at Article 17, MS 301. The gender directive at tab 14, again later in time, tab 14, MS 317 is to like effect, material terms. And so we see at MS 320, the purpose, Article 1, equal treatment of men and women in relation to employment in particular. Article 2, defining the concepts of discrimination. And then Article 14, one has to go some way in because this directive also deals with equal pay. Article 14, MS 324, contains the relevant prohibition. And again, at 1C, Article 14, 1C, covers dismissals. Article 17, judicial control. And Article 18, compensation and reparation. So, 3 equality directives covering the protected grounds covered now by domestic law, each requiring member states to prohibit discriminatory dismissals with no material exemptions. So we say as a matter of EU law, the appellant is entitled to be protected against a discriminatory dismissal and to have a right to bring a claim in respect of it. As to the relevant regulations, the applicable regulations governing dismissal at a misconduct hearing in the case of police officers, the applicable regulations are at Authorities Volume 1, Tab 5, MS 193, Volume 1, Tab 5, MS 193. The relevant history, that is something of the predecessor regulations, is described at Annex 1 to the respondent's case, core volume MS 5057, and that may help your ladyship and your lordships in due course in the event that it's necessary to look backwards. But as we've said in our written case, the trend has been, I'll flag up one matter in a moment, the trend has been to make the proceedings more informal and more analogous to proceedings that would ordinarily take place within a workplace environment. So whilst they're still fairly formal, they more closely reflect ordinary workplace disciplinary procedures. As to the relevant regulations, then, starting with interpretation, MS 195 under Regulation 3, turning over to 196, we can see the meaning afforded appropriate authority, flag this because we'll come back to this in due course, but the appropriate authority in the case of a senior officer is the police authority, so MOPAC here. In any other case, the chief officer, so the Met Police Commissioner. At the bottom of the page, gross misconduct is defined, breach of the standards of professional behaviour, so serious that the dismissal would be justified. 197, misconduct means a breach of the standards, so we've got a gross breach and a breach. Those standards are set out in the schedule to the regulations at MS 227. And they include matters such as, MS 227, and they include matters such as honesty and integrity, authority, quality and diversity, force, etc., as well as fitness for duty. There is also, just above misconduct at 197, again, so I don't have to come back to it, 197, management action is defined. Management action is advice intended to improve the conduct of the officer concerned. So you will have seen in various parts of the written cases, as I've indicated, the move towards procedures which more closely reflect ordinary disciplinary procedures at work, designed to improve performance, not merely address charges in the old formal sense adopted by predecessor regulations. Under misconduct on the same page, misconduct hearing is defined, and I'll take you to the relevant provisions, and misconduct meeting, which is something rather different. And then finally, at the bottom of that page, MS 197, a senior officer is defined as a member of the police force holding a rank above that of chief superintendent. That's important because, as my lady and your lordships will have picked up, there is a distinction as between the way chief officers and non-senior officers are dealt with under the regulations. I'm not sure that's material now. I can't quite tell, but we'll see in due course. So looking then at the substance of the regulations, first of all, Regulation 5, MS 199. The regulations apply where an allegation comes to the attention of an appropriate authority which indicates that the conduct of a police officer may amount to misconduct or gross misconduct. So where an allegation comes to the attention of the chief constable, or in the case of a senior officer, MOPAC, then the regulations apply. There are various provisions addressing thereafter, just descend into the detail, but addressing the right to a police friend, so a workplace friend, to assist in the circumstances, and in some contexts to have a lawyer, that would be at a misconduct hearing or a special case hearing. See that at MS 200, Regulation 7. At Regulation 9, MS 200, unsurprisingly, where there are potential criminal proceedings, then the misconduct proceedings will be stayed. Assuming that there is a conclusion reached that such might prejudice any criminal proceedings. And then at MS 202, the process starts in reality with under Regulation 12, MS 202, subject to paragraph 6, where there's and that's a decision to take no action under these regulations but refer to the performance regulations. Subject to paragraph 6, the appropriate authority, Met Police Commissioner or MOPAC, shall assess whether the conduct, which is the subject matter of the allegation, would amount to misconduct or gross misconduct. Where the authority assesses that the conduct, if proved, would amount to neither misconduct nor gross misconduct, it may take no action or take management action. So in other words, provide advice directed at securing improvements in the officer's conduct, or refer the matter to performance regulations. And then at 3, where the appropriate authority assesses that the conduct, if proved, would amount to misconduct, it shall determine whether or not it's necessary for the matter to be investigated, and if so, the matter shall be investigated, and the appropriate authority shall determine whether, if that matter were to be referred to misconduct proceedings, they would be a misconduct meeting or a misconduct hearing. So, following an assessment, it will decide, is this matter serious enough really to go further? If not, you can give some guidance and advice, or refer on to the performance regulations, which will deal with issues of capability. Otherwise, the question arises whether it's serious enough to go to a misconduct hearing or a misconduct meeting. And then at subsection 4, subregulation 4, where the appropriate authority determines that the conduct, if proved, would amount to gross misconduct, the matter shall be investigated. No question of moving it on, but there may be a revision of that at any point thereafter. Moving on then to Regulation 19. The investigation takes place, and at Regulation 19, this deals with a reference or a referral for the purposes of misconduct proceedings. Regulation 19, subject to Regulation 41, which concerns special case hearings, which I needn't trouble you with at the moment. Subject to Regulation 41, on receipt of the investigator's written report, leave out A and B and just go to the substantive next part, the appropriate authority shall, as soon as practicable, determine whether the officer concerned has a case to answer in respect of gross misconduct or gross misconduct, or whether there's no case to answer. And then subsection 3, I can take you through the rest, where the appropriate authority determines there's no case, may take no further action or take management action. So again, where there's no case to answer, nevertheless, may take action designed at improving an officer's performance. And then 4, subregulation 4, where the appropriate authority determines there's a case to answer in respect of gross misconduct, it shall, subject to 9.3, which is the criminal procedures obligation to stay or consider a stay, refer the case to a misconduct hearing. So where there's a case to answer in case of gross misconduct, which of course could lead to dismissal, it goes to a misconduct hearing. Subregulation 5, where it determines there's no, where it determines there's no case to answer in respect of misconduct, that is not gross misconduct, mere misconduct, again, it may refer the case to misconduct proceedings or take management action. In the case of misconduct proceedings for misconduct, that may be a misconduct meeting and is not necessarily a misconduct hearing. And we see that at Regulation 25, dealing with misconduct proceedings. So must go to a hearing if it's gross misconduct, otherwise will go to misconduct proceedings, whether gross or not, in the event that there's a case to answer. Regulation 25, this regulation applies where the officer concerned is an officer other than a senior officer, that's us, separate provision made for senior officers. The misconduct meeting, and as I've indicated in the case of mere misconduct, an officer may be subject to a misconduct meeting, shall be conducted by a person appointed by the appropriate authority, Chief Constable, Met Commissioner here, who's not an interested party and who satisfies paragraph 3. That is, member of the where the officer is a member of a police force, another member of a police force of at least one rank higher. So a superior officer. So misconduct meeting to determine whether or not there's a case of misconduct. A more senior officer, and in the case of a special constable, similar provision made. And B, unless the case substantially involves operational matters, by a police staff member. So in the case of a misconduct meeting, an officer of a rank above, or a police staff member, no doubt a human resources person, so long as it doesn't involve operational policing matters. Now we say, first of all, on any analysis, a police officer, a rank above, or a human resources officer sitting across a table from a police constable who's said to have committed an act of misconduct cannot attract judicial immunity. And I don't think it could sensibly be suggested otherwise. In the case of a misconduct hearing, which is what we're concerned with here, MS 210 over the page, subregulation 4, where the case is referred to a misconduct hearing, the hearing shall be conducted by a panel of 3 persons appointed by the appropriate authority, comprising a senior officer or a senior human resources professional, the chair. B, where the chair is a senior officer, a member of the police force of the rank of superintendent or human resources professional, where the chair is a human resources professional, a member of the police force of superintendent rank or above. So 2 officers and 1 human resources person. Or the other way round. Yes? Mr. Linden is scratching his head.
Well, so far, we've got the chair under A, and B gives us 1 other member, doesn't
Yes.
it? Yeah.
So chair can be a senior officer. So chair can be a senior officer. Then there's a human resources officer or a member of the police. And did I not read little c? I'm sorry. A person selected by the Metropolitan Police Commissioner from a list of candidates maintained by a police authority. And we saw in the notice of the decision concerning the appellant that was a person from MOPAC.
But you could have 1 police officer, 1 human resources professional, and 1 another.
You could. And the another will be somebody appointed from a list, and to the extent that we can determine, that would be a MOPAC person, and quite probably, as here, no doubt, a human resources person, since the other 2 members of the panel were police officers.
In this case, yes, but if we're interested in the general scheme, presumably C could be somebody who's nothing to do with either the police authority or or an officer.
Yes.
Local person with an interest in public affairs, for example.
Yes, I don't know if in reality that ever happens,
Nor do I.
but I understand entirely that so far as the regulations are concerned,
Yep.
a list is drawn up, and an appropriate person from that list is...
Does any regulation say anything about what sort of person might be on the list?
Not that I recall, and I can see the respondents not suggesting otherwise. Not that I have seen, and I don't hear anything from the respondent. No doubt Mr. Linden will tell you when he makes his submissions if he knows something I don't. But at the moment, it's a list prepared by the appropriate authority for the purposes of adding another to the panel. Different provision is made. So under 5, so just to finish this off, regulation sub 5, it does define senior human resources professional, and it is what it is. It's a senior human resources professional.
Well, one can imagine if there were a definition of who might be suitable to be on the list, it would be in somewhat similar terms.
Precisely. So perhaps whoever drafted it thought better of it. Chief constables are dealt with differently at misconduct proceedings. So chief constables, their misconduct proceedings conducted by a panel, chair of the police authority, chief inspector of the constabulary, or an inspector of the constabulary nominated by him in the case of a misconduct meeting, and for a hearing under sub-regulation So 26.3, a barrister selected from a list, chair of the police authority, Her Majesty's Inspector of Constabulary, or person nominated, and then a person from a appropriate authority.
So does that contemplate as a matter of interest, does it contemplate a panel of 4?
Yes.
Does it?
I suspect because getting rid of a chief constable is regarded as rather more.
Well, I can
a rather
understand
sore
why
amount
it's
of
more,
matters.
Miss Monaghan. I just wondered why it was an even number.
Oh, I see. I see. I misunderstood.
Anyway,
yes.
there we are. Yep.
I think there is provision made that's indicating, I can't quite remember where I've seen it, that the chair has the casting vote.
I imagine it might
but
have to be. Yes.
I can't bring it to mind. But if it's helpful
Yep.
to do so, I can pick it up. And then Regulation 27 deals with senior officers. I won't read it through, but you'll see more senior officers are on the misconduct meeting panel. So you'll see that. And then misconduct hearing under 3. Again, more senior officers and the chair of the police authority and a person selected from a list. Again, my recollection is that this can be dealt with by a majority. And in fact, I've now found it, just for your note, my lord, it's 34-15.
Thank you very much.
Chair has the casting vote. 34-15. So that's the general scheme so far as commencing proceedings and constituting the panel. And then Regulation 32, MS 213. You'll see that misconduct proceedings are held in private. Regulation, says there are exceptions to that, I should say, where the misconduct proceedings follow a reference from the IPCC, but we're not concerned with that here. The default position is that misconduct proceedings are held in private. That position is changed, but under the regulations we're concerned with, that was the position. And then procedure at misconduct proceedings, Regulation 34, MS 214. Regulation 34.1, the person conducting or chairing shall determine the procedure. And then at 34.13, the obligation of those conducting the proceedings, meeting or hearing as the case may be, must decide whether or not the conduct amounts to misconduct or gross misconduct. And 14, the balance of probabilities being the referable standard. And 34.15, I've just directed your ladyship's and your lordship's attention to. 36.2a, sorry, I beg your pardon, I jumped ahead of myself. I should have, of course, taken you to Regulation 35 that deals with outcome. Regulation 35, MS 215. So findings are made. Regulation 35, the persons or persons conducting the misconduct proceedings may impose any disciplinary sanction in paragraph 2A, etc. Or B, where they find the conduct amounts to misconduct but not gross misconduct following a misconduct meeting or hearing, record a finding but take no further action. Importantly, and I simply flag here, that for the purposes of this part, it is the misconduct meeting or hearing that dispenses the sanction. And then at 2 onwards, the disciplinary action is defined, warnings and so on, designed to improve performance. At a misconduct hearing, under 2B, so 35.2b, the sanction may be, Roman numeral 4 and 5, dismissal with or without notice. Our dismissal, as your ladyship and your lordship saw, was a without notice dismissal. And at 35(3), that disciplinary action has effect from the date on which it's notified to the officer concerned, or in the case of dismissal with notice, the end of the period of notice. We're a without notice dismissal, so the handing down, the dispensing of or determination of that dismissal by the panel was effected at the time it was handed down. And at paragraph 9 over the page, 35(9)(216), where there's a finding of gross misconduct and the persons conducting the misconduct hearing decide the officer concerned shall be dismissed, the dismissal shall be without notice. So in all cases, the decision itself affects the sanction, gives effect to the dismissal, and it will always be without notice in the case of gross misconduct. Regulation 36 deals with notification of the outcome, and the only matter that I need to draw your lordship's attention and your ladyship's attention to at the moment, though I'll have to come back to, is 36(2)(a), where the officer is an officer other than a senior officer. 2, the notification must include notice of his right to appeal to a police appeals tribunal.
As a matter of interest, if a finding of misconduct is made, is the opportunity given to enter a plea in mitigation, so to speak?
Yes.
Yeah. So the finding of misconduct would not necessarily be contemporaneous with a dismissal?
No, I beg your pardon, sorry, that's all wrapped up into, there's no further mitigation. There is in fact in relation to senior officers, as we'll come to, there's a second hearing. But in relation to non-senior officers, as is the case with our client, so far as the regulations are concerned, the misconduct hearing panel makes a decision on making their findings of fact, bearing in mind any mitigating factors.
You've got to get your mitigation in first.
You've got to get your mitigation in first.
Could be either, couldn't it? I mean, the
They can do what they-
34(1) gives the chairman ample power to decide if she wants to notify the decision on conduct and then give the opportunity for address on mitigation, doesn't it? What the practice is a different question.
Well, it's your lordship's right. It would seem to allow that. Certainly, it appears in this case that it was all dealt with in one go, and of course. Well,
was there a dispute in the present case that it was gross misconduct?
Yes, there was an admission that it was misconduct,
yes,
but not an admission that it was gross misconduct in reliance on the claimant's disability. And so it was wrapped up into the single question. And of course, where there is a finding of gross misconduct, as I've just taken your ladyship and your lordships to, and it's decided to dismiss, that will always be without notice.
Yes, but it begs the question whether there is a decision to dismiss or something else.
Yes.
Yeah.
Is it the case that a person can be dismissed without notice for simple misconduct?
Yes. That if one looks backwards, you'll see
that seems to follow, yes. But it's
yes,
quite unusual.
Yes.
But it is possible for a finding of gross misconduct without necessarily being dismissed.
Yeah.
That appears to be the effect of the regulations, because it provides general discretion as to sanction, and then at 9 determines that where there is a dismissal, it will be without notice.
So despite the complexity of the regulations, there is a reasonable amount of flexibility built into it. I mean, for example, misconduct might, I suppose, sometimes be thought to justify dismissal if it had been repeated
yes,
on too often.
Yes, and if there'd been written warnings, for
sort of
example,
thing.
and there is provision made for written warnings,
Yeah.
if there'd been written warnings and the misconduct had continued, then one might see eventually a dismissal for misconduct, just as one would in an ordinary workplace environment.
Yeah.
But where a finding of misconduct is made, if one analogizes it with a criminal proceeding, if a finding of guilt is made, that will be made on a certain basis, and it would be on that basis that the mitigation would be tailored. But do I understand that, certainly in this case, and from your understanding, in the general run-of-the-mill case, where a finding of gross misconduct is made, there's no opportunity to make a mitigation plea?
So far as I can deduce from what happened here, based on my instructions, there was a single hearing at which all matters were determined. There was a finding of gross misconduct, notwithstanding the matters put forward by way of explanation, and in the context of an admission of misconduct, but not gross misconduct, a determination that it was gross, and then the imposition of a sanction.
Right.
Now, that's not to say, of course, that mitigation wasn't had regard to in determining what the appropriate sanction was, but it appears to have been rolled up in a single hearing.
Because in this case, by the sound of it, from what you've said, the principal argument, there was a bit of an argument on the facts, but principally the argument was that it was all attributable to her disability. Yeah. And that was the reason why it wasn't gross misconduct.
Yes, precisely. So she admitted...
It took place over 2 days, so it is possible that the finding of gross misconduct was made at the end of the first day.
Yes.
And then mitigation was entered at the beginning of the second.
It is. Or it's also possible that the whole thing was dealt with in one go, and the hearing panel decided, notwithstanding the mitigation, it's gross misconduct, and given its gross misconduct in the circumstances, it's sufficiently gross for the mitigation not to lead us to do anything other than summarily dismiss. But I can't help you any further than that, I'm afraid, because I only have my client's case to go on. At Regulation 38, it deals with appeals from misconduct meetings. I needn't trouble you with that. Again, it's at a lower level, concerned here with appeals before other officers. So in other words, it's a fairly low-level appeal process. Regulation 41 onwards deals with special cases. I needn't trouble you with that, but just so your ladyship and your lordships know what it's about, it concerns essentially urgent cases where the appropriate authority has decided we've got to get rid of this police officer quick. So there had been concerns in the past about police officers who were plainly ill-suited to continuing in the police force, hanging around for long periods of time while lengthy misconduct proceedings were gone through, with consequential pension entitlements and so on accruing. So there is now a speedy procedure, but it doesn't affect the issues in this case.
So there's quite a lot on those, actually, isn't there? The whole of Part 5 is those, is it?
Yes, it is.
Yep.
And there are conditions applied, and there is a summary procedure. Witnesses aren't called and so on. So it's in cases where there is very obviously very serious misconduct. I mean, one can imagine.
There are more regulations dealing with the summary process than there are dealing with the standard.
But I think a lot of them are exclusionary. You can't do this, you can't do that, you can't have witnesses and so on. Yeah. But one can imagine a circumstance where it would be reputationally very damaging and inappropriate otherwise to allow an officer who was plainly guilty, self-evidently guilty of serious misconduct to remain in the police force while a lengthy procedure was gone through. So that deals with that. Those regulations, as you will have seen, my lady and my lords, have been repealed and replaced with the 2012 regulations. I needn't take you to all of them. Two significant points to note, although I'm not sure how significant they are. I haven't quite worked out how significant Section 42 is yet. But the 2 points that I draw your ladyship's and your lordship's attention to. Firstly, in relation to officers of the appellant's rank, hearing panels are constituted in precisely the same way, and disciplinary sanctions handed down by the misconduct panels. However, in the case of senior officers, it's now the chief officer, the Metropolitan Police Commissioner, or the policing authority, where it's the chief officer concerned, that hands down the sanction. We see that at MS 266. This was material to the question, is it an act by chief officer such that Section 42 attaches or not, as the case may be. As I say, I'm not entirely sure in my own mind where we are with that, but we'll see at Regulation 3316 at MS 266. Where the officer concerned is a senior officer, the persons conducting the misconduct proceedings shall, as soon as reasonably practicable after the meeting or hearing, submit a report to the appropriate authority with a copy to the senior officer and the reasons for the finding and so on. There's then a further meeting at Regulation 34. This is senior officers. And then at 35.2, at that meeting, that is the Regulation 34 meeting, a disciplinary sanction may be applied.
So does it follow from that that now, under these new regulations, in the case of senior officers, not only is the decision not handed down by the panel, but the panel's decision doesn't bind
It's
either the authority or the chief constable, as the case may be?
not in relation to sanction. In relation to
Quite.
it holds a further hearing, so the findings are in the report under.
And by the findings of fact, but not of the sanction.
Well, I'm not sure if it says in terms that they're bound by the findings of fact, but in any event, there is a provision made for the appropriate authority to hand down, or sanction the officer, but that, of course, is discretionary in any event. In other words, the choice of sanction, insofar as one is handed down, is now not a matter for the hearing panel.
And that's 34, is it?
34 read with 35.
Well, 35 is people other than senior officers.
And then at 35.2,
Yeah.
subject to the provisions of this regulation, a meeting or hearing held under Regulation 34, and Regulation 34 deals with the further meeting in the case of senior officers.
Quite. So for non-senior officers, what's the present position?
The same.
As it was before?
Yes.
Yeah.
For completeness, I should say that there's been an amendment to those regulations. I won't take you to them, but there are 2015 regulations, Volume 1, Tab 8, MS 285, that do alter the constitution of the hearing panel in the case of officers of the appellant's rank. They are now constituted by a lawyer, a police officer, and another, CMS 286, and hearings are generally in public. The default position is that they're in public.
So there's greater formality.
There is a difference. MS 287, again, I mean, leadership will know better than me, I'm sure. There are lots of concerns about private disciplinary hearings.
Sure.
And so the default position is that they're in public. There are also, I won't take you to them, but just again to complete the picture, what are called performance regulations. They're at volume 6, tab 74, MS 677, no, 167. Sorry, let me just check that. My number can't be right.
It's tab 74.
Tab 74, yes, sorry, tab 74, volume 6.
It's
tab
1677.
1677, yeah, thank you. They're concerned with unsatisfactory performance, capability, and so on. They're not directed towards misconduct. And there is a staged process, again, consistent with the scheme ordinarily seen in workplaces, a series of meetings, performance, advice, and targets, and so on, escalating in an effort to achieve a better performance and attendance. Those are, I suppose, the first stage disciplinary proceedings. There is then a right to appeal to the Police Appeals Tribunal, as I flagged up to your ladyship and your lordships. The rules in relation to those appeals are found at tab 6, volume 1, MS 231. The respondent says, does the appellant say that judicial immunity applies to this tribunal? The short answer to which is, we're not concerned with that tribunal. That tribunal does not dismiss, it hears appeals. It may reinstate, but this is not a reinstatement claim. I beg your pardon, sorry. Is that better? It may reinstate, but we're not concerned with reinstatement, we're concerned with dismissal. It may not be a judicial body, and we certainly don't concede it is. It is not, in any event, independent, and that would be highly relevant to the question whether it's a judicial body. I need to take you just to one part of the rules. The 233, MS 233, you'll see that the grounds of appeal available under Regulation 4 MS 233 are limited. Was the finding or action unreasonable? Is there fresh evidence? Or was there a breach of procedure?
Or other unfairness?
Yes, or other unfairness. It does not permit, certainly in terms, an officer or an ex-officer to complain of discrimination. Of course, one may say that necessarily, if a finding was made on a discriminatory basis, it would be unreasonable or unfair. But it doesn't, of course, provide a remedy for that unfairness beyond a quashing of the sanction, and nor are there any special procedures in place of the sort found in employment tribunals for the assessing of complaints of discrimination, specialist tribunal members and the like.
As to what the appeal tribunal can do if it considers that the grounds of appeal have been made out, I don't think we really collect that, do we, Miss Monaghan, from these regulations? Think we've got to go to the 1996 Act?
I'll just check my note. Schedule 6, you're right, I beg your pardon, it's Schedule 6 of the Police Act, but that's not in the bundle, I don't think.
I rather thought
sorry. Well, then,
I rather thought that in Bundle 5, tab 44,
I'm grateful.
if we went to section 85.2, we might get the answer.
I'm grateful, thank you. What was the...
1202.
I'm grateful, thank you, and I'm terribly sorry about that. Yes, so I'm grateful, my Lord, thank you. So 1201, section 85, and subsection 2, as your Lordship says, deals with the powers of the appeal tribunal, can deal with them in a less severe way, and in a way which could have been dealt with by the initial hearing panel.
That's section 85 of the Act, is it?
That's of the Act, that's the Police Act 1996, MS 1201-2, Volume 5, tab 44. I'm grateful, my Lord. Yes, and just to bottom that out, thank you, Mr. Kemp's just reminded me, at 1207, if your Lordships and your Ladyship are still in that tab, it deals with the effect of an order of the appeals tribunal. Where an appeal is allowed, the order shall take effect by way of substitution, and as from the date of that decision, or where the decision was itself a decision on appeal, the date of the original decision appealed against. So it has retrospective impact. If you're dismissed summarily, you get your pay in the meantime if there is an effective reinstatement. That's a tour around the not terribly easy regulations applicable to police misconduct. Coming then to the question of judicial immunity, ground 1 of the appellant's grounds of appeal. Does judicial immunity attach at all as a matter of common law? The most important case referred to below, and that which all of the tribunals, including the Court of Appeal, felt bound by, is the case of Heath, Volume 2, Tab 19, MS 524. Volume 2, Tab 19, MS 524. This was a claim of sex discrimination, just before I come to the relevant parts, brought not by the police officer that was the subject of the disciplinary process, but by the complainant who had complained of sex discrimination, among other things, in the way that the board had conducted themselves in relation to her. So she complained sex discrimination by the board in the way that they had conducted themselves. She was
the complainant against, she was a civilian, wasn't she? She was a complainant against a police officer.
Yes.
And her discrimination complaint was of discrimination in the way that the board had dealt with her complaint, basically.
Precisely.
And she couldn't have appealed to the appeals tribunal.
She couldn't have appealed to the appeals tribunal. She had no remedy, save in sex discrimination under the employment provisions of the Sex Discrimination Act.
And that because she happened to be, although she was a civilian, she was an employee.
She was an employee of the force.
Yeah.
And you'll have seen the description of the treatment about which she complained. Question was dealt with without, of course, any findings in relation to that, but on the basis that judicial judicial proceedings immunity applied to the board, and therefore she couldn't bring a claim in respect of their conduct. I'll come to the relevant parts. There was, as your ladyship and your lordships will have perhaps spotted, a dissent in part by Lord Justice, as he then was, Neuberger, but that's not material. The dissent concerned only the fact that the Lord Neuberger considered alone that the claimant was entitled to bring a complaint as to the way in which the board was constituted, all male, that being a decision of the chief officer, so not falling within the scope of judicial immunity. That didn't find favour with the majority, but it's not of any significance here. First of all, then, please, if I can take you to the approach of the Court of Appeal to the width of the rule generally. So how far does it extend? MS 533. I suspect this isn't controversial now, but there was an argument made in Heath that to the extent that any immunity applied, judicial proceedings immunity applied, it applied only in respect of defamatory statements. So it didn't apply any more broadly than that. Perhaps unsurprisingly, given the look on my Lord Hughes's face at that point, the Court of Appeal said no. So you're safe, my lady and my lords. It extends much further than mere defamatory claims, and it sets out at 533 onwards. As I've indicated, I doubt it's necessary to read it, but in essence, citing earlier case law, the Court of Appeal made clear that where judicial immunity applies, it applies to anything done as well as anything said. And you can find that in the extract from Darker, 534, top of the page in the extract, or all things said and all things done. And then at paragraph 19, it follows that if the absolute immunity rule is not to apply to claims before an employment tribunal for unlawful sex discrimination, it cannot be based on the proposition that it only attaches to defamation claims. So it's a wide immunity covering everything said and done. That's very significant because, of course, in determining proportionality in due course, we can see that it's a very wide immunity and has the effect of barring any proceedings at all seeking to impugn the acts or words of a judicial body. As to what's meant by a judicial body, tribunal, that's dealt with at MS 535. There's great reliance placed on trap, which I'll come to in due course. 21 deals with the issues of principle, paragraph 21, 535. The nature of the exercise in determining whether a body is to be regarded as judicial for the purposes of giving absolute immunity to those involved in its proceedings is not a technical or precise one. That does mean it does make it terribly difficult to spot one when one sees one, but there we are. It's one of determining its similarity in function and procedures to those of a court of law. It's a matter of fact and degree. And then at paragraph 22, in reliance on the guidance in Trapp and McKee, or repeating the guidance in Trapp and McKee, which the Court of Appeal adopt, identifies certain factors that will be material. Paragraph 22, the test of similarity identified 4 aspects for consideration: whether the tribunal is recognised by law, whether the issue is akin to that of a civil or criminal issue in the courts, and pausing there, that is likely to be a very great significance to the issues here, because as you'll see, we say the matters to be determined by a misconduct hearing cannot be said to be akin to a civil issue. 3, whether its procedures are akin to those in civil or criminal courts, and whether the result of its procedures leads to a binding determination of the civil rights of a party. I emphasise civil rights, so whether the issue is akin to a civil issue and whether it's determinative of a civil right. And then towards the bottom of that same page, again an extract from Trapp and McKee, no single touchstone emerges.
I suspect it might be Mackey. I think it was a Scottish case.
Sorry,
Wasn't it? Yes. So it'll probably be Mackey.
I've got absolutely no excuse for that because my grandmother's Scottish, forgive me. Mackey. Trapp and Mackey, but the extract towards the bottom of the page, no single touchstone emerges from the cases, but this not surprising, for the rule of law is one which involves balancing of conflicting public policies. So pausing there, again, no certainty about the meaning to be afforded, the criteria for determining when a body is a judicial body, certain factors relevant to consideration, but no single touchstone emerges, and there is a balancing exercise to be undertaken, recognising the right generally to provide a remedy to those adversely affected by a decision or conduct of a tribunal or board, as well as the need to protect the integrity of the justice system. Again, very important because, as your ladyship and your lordships will have seen, both from the appellant's case and from the Equality and Human Rights Commission case, it said here that there are other weighty considerations that the court must have regard to in determining where the balance lies and what factors are more or less important in reaching the conclusion that in due course it will come to on the question of judicial immunity. Paragraph 24, in deciding, again citing from Trapp and Mackey, in deciding whether a particular tribunal is of such a kind as to attract absolute privilege for witnesses when they give testimony before it, your lordships are engaged in the task of balancing against one another public interests which conflicts. In such a task, legal technicalities have at post a minor part to play. I don't say, my lady and my lords, that this is terribly helpful, because it does mean there is both the need to identify relevant characteristics which go to the question whether this is a judicial tribunal, but at the same time, balancing competing interests, almost, if I may say so, and perhaps indeed, undertaking a proportionality analysis, something that's picked up, something that can be discerned perhaps in particular from the judgment of my Lord Reid in Pham, where one is looking at an interference in fundamental rights. It might be said that even at common law, there is a proportionality analysis to be undertaken. But in any event, one's undertaking a balancing exercise, weighing against each other the importance of the respective considerations.
It's quite interesting that the considerations, the public policy considerations that are identified in that case have to do with witness immunity.
Yes.
Rather than with judicial immunity. It would be, one would need then to work out, well, what are the conflicting public policy considerations dealing with the immunity of the body making, the decision-making body.
The court.
Yes, or tribunal, or whatever.
Yes, but taking it at its highest, the court. We've supposed in our printed case, written case, that matters such as independence need not to be sure that the vexatious litigation doesn't follow from any decision, for example, by this court, including by perhaps the state, put at its most chilling, but to protect the integrity of the process, bearing in mind, of course, that generally, certainly in formal courts, there will be the opportunity to appeal. Whilst, of course, ultimately in this court, there isn't the opportunity to appeal, absent a reference, I suppose, to the Court of Justice, not of course, technically an appeal, but certainly in the lower courts, there will be the opportunity to appeal. An absolute immunity, certainly we haven't suggested that it doesn't pursue a legitimate aim, ensuring that courts aren't troubled by vexatious collateral litigation when an appeals process deals with it, and judges are free and able to make even the most unpopular of decisions without risk of vexatious litigation. So guaranteeing the integrity of the process. So certainly so far as courts proper are concerned, we don't say that it doesn't pursue a legitimate aim, but it does highlight the need to show caution. In a formal court, where one is making binding decisions, creating law in a common law jurisdiction, it might be said that there are important values at stake, but the lower down the hierarchy, the less formal, the less binding a decision is, then of course the less the justification for that wide immunity, particularly where it flies in the face of important fundamental rights.
May I just ask, either yes or no, because you're obviously coming to it, are you conducting this argument on the basis that the immunity for the tribunal and its members and the immunity for witnesses necessarily go together, or not?
We hadn't actually, we certainly haven't looked at it in that way.
You don't think they do go together, or you hadn't considered it at all?
We haven't considered it.
Right.
We've taken the view that immunity doesn't apply at all.
Yes.
And haven't treated it as we've treated it as an all or nothing.
You have.
If the body is not a judicial body, there's no immunity. If it is a judicial body, then absolute immunity attaches. Certainly the approach in Heath seems to be that the drawing of lines as between the breadth of the immunity is not appropriate. Where you have a judicial body, it is absolutely immune.
It is all or nothing.
It's all or nothing. Well, certainly so far as Heath is concerned, and we haven't approached it any differently. And of course that means in the context of a disciplinary hearing, Ms. Heath, being an employee of the force in which the officer is engaged, can be said, if Heath is right, to be subject to any forms of discriminatory treatment by the panel, and indeed by the officer in the context of those proceedings, without recourse to the Employment Tribunal for sex discrimination. My Lord, I thought you were about to ask a question. I'm sorry. No.
No, I was just recollecting a hearing where I had a litigant in person from an ethnic minority who served me with the appropriate form under the Race Discrimination Act at the end of a hearing, along with all the other members of the court. And his complaint was that I had sought to assist him in making his submissions, whereas I hadn't sought to assist counsel. And this was obviously discriminatory treatment.
It's obviously a device to, no doubt, make his submissions less compelling than they otherwise would have been.
Well, perhaps illustrates why we have this sort of immunity.
Well, precisely. And as I say, we don't say it doesn't pursue a legitimate aim, but it does reinforce the need to be careful about the scope of its application. In a case like Heath, it was, I think, the officer's representative who asked her to squeeze her own breast to demonstrate the assault that she alleged had taken place. Now, that is without doubt an act of sexual harassment under the Act, but she has no recourse to a remedy, despite the fact that that occurs during the course of her employment and at the direction of a co-worker. a police officer in that case. So care about the width of it. As to the various factors then, and applying them to the board, as the Court of Appeal did in Trapp, under paragraph 26, dealing with tribunal recognised by law, needn't trouble your lordships with that. Plainly, this panel is recognised by law, but we make the point that that might be said of very many disciplinary panels, depending on how one defines the law for these purposes. Many disciplinary panels, perhaps most, certainly in the public sector, are regulated by highly complex contractual procedures, sometimes consequential upon binding collective agreements, sometimes not. To that extent, can be equally said to be regulated or not recognised, by law. As to whether the proceedings are sufficiently, over the page, sufficiently judicial, the similarity question, I won't read it all to you because it's long, but we've just looked at that. Paragraph 27. I won't read you the whole section because it's very long, 537. But again, looking at the question of civil, whether or not there's an issue akin to a civil issue, paragraph 27, the second category of similarity is that the issue for determination must be akin to the subject matter of civil suits in courts of justice and includes in the former category the right to dismiss, as was a possible consequence for the inspector here. The question for determination by a panel, as with any other workplace disciplinary hearing, is not whether there is a right to dismiss, a legal right to dismiss. The question is whether to dismiss, bearing in mind workplace standards of conduct. As has been said in a later case that I'll take you to briefly, when an employer dismisses, it is not determining whether it has the right to dismiss, it is asserting a right to dismiss. There is no determination of any civil right, there is an assertion of a right.
Well, you would presumably say that despite its statutory underpinnings, this process is far more like any other employer's disciplinary processes, which are often the subject of, or usually the subject of contractual arrangements, than it is like the determination in a court of law.
Precisely.
That's your basic point.
The basic point is that, precisely that, and for reasons that we've elaborated upon in our written case, it is a workplace disciplinary process and has been picked up in later cases when the Court of Appeal has said the principle of issue estoppel does not apply to workplace disciplinary procedures. Many disciplinary procedures, particularly in the public sector, are enormously complex. That doesn't make them judicial. The fact that it confers entitlements on workers, like the rights to representation, the rights to provide mitigation, the right to notice of allegations and so on, doesn't make them judicial proceedings. They are workplace disciplinary procedures, and the hearing panels in issue here, whilst formal, are no different in substance. They do not determine any rights.
Is the status of a police officer relevant to this or not? I don't mean the formal status of whether he's employed or not, or she is employed or not. I mean the public functions, the not inconsiderable powers that she has, the impact that the police force has on the public generally. Is all of that relevant or not?
We say no.
It's simply a job.
It's a job, it's an important job, and of course it may be relevant in other contexts. It has proved relevant under Article 6, although not so now, we say. But for these purposes, no, and particularly when one looks at the broader context, which is that Parliament has decided that notwithstanding their special position, police officers are entitled to the same work-based rights as other workers, as has EU law. So for these purposes, there's nothing special about the disciplinary procedures that apply. We'll come to in the moment, it's not only anti-discrimination rights police officers have, it's whistleblowing rights. Same considerations apply.
Yeah. I'm sorry.
So simply that in my submission in this context, no, mindful of the fact that whilst the proceedings are complex and formal, they exist in a context where many disciplinary processes are complex and formal, and where Parliament has afforded police officers the same rights as ordinary workers to bring claims of discrimination. They're not treated for these purposes
That's
differently.
procedure. At the moment, what we're on is issue. And the four Trapp and Mackey criteria do, for whether rightly or wrongly, distinguish between them.
Sorry, I was looking at the issue more broadly. So insofar as the issue is concerned, no, the issue remains the same.
Yeah.
Is there misconduct? The misconduct, misconduct is tested against the standards of conduct contained within the regulations, but ordinarily contained in disciplinary procedures in a workplace. Misconduct at work measured against standards of conduct expected, and a determination as to what sanction to apply. In that context, an employer asserting, properly analysed, a right to dismiss or apply some other sanction in accordance with the contract or regulatory procedures, as the case may be.
So if the outcome is dismissal, which means you lose your right to remuneration and you lose your powers of a constable, why doesn't that amount to issues akin to civil issues?
Because it's not a binding determination on the question. There isn't a dispute at that time inter partes. The dispute concerns the question whether or not the police force had the legal right to dismiss you, whether it was discriminatory, whether it was unfair in certain circumstances. Where an employer dismisses, it is reserving for itself the right to dismiss, but it isn't determining whether it has the power to dismiss. That will be for any independent adjudication thereafter. It cannot
Not
determine.
so much the power to dismiss as to whether it was reasonable to dismiss.
Yes. I
Or
mean, this is,
lawful. I mean, it might,
Or lawful.
It might be an unlawful dismissal, it might be an unfair dismissal. There might be all sorts of reasons to challenge the dismissal. Your point, as I understand it, is that this is really just like any other employer's decision to dismiss, following, as almost invariably these days is the case, a formal process.
Yes.
Which will, of course, unless challenged, have the effect of stopping salaries and stopping people being able to use the workplace and use the workplace equipment or do the things that you could do having that particular job, including boss other people about. But that doesn't determine whether the employer was right to do it.
Precisely. It's not a determination of a legal dispute between the parties. It's a determination as to whether or not, bearing in mind the regulatory scheme and the disciplinary procedures, the employer exercises its discretion and considers itself entitled to exercise its discretion, asserting a right, as it's later described, to dismiss. But whether or not that's lawful is ultimately a matter for an independent tribunal, a court, which will properly attract judicial immunity.
Yeah. But forgive me, in the case of orthodox employment, dare I call it private employment, but it would include the public sector as well. But in case of orthodox employment, the kinds of procedures that are put in place for disciplinary action, including dismissal, are there are they principally for the protection of the employee?
Yes.
Now, are these provisions in the police misconduct regulations there primarily for the protection of the police officer, or are they also there to give effect to the very important public interest that people shouldn't be exercising the powers of policemen unless they're behaving properly?
Yes, but of course that applies equally in the case of a social worker.
Social workers don't have quite the same statutory or common law powers, but they have some.
Yes, and they have having a social worker that is not adequately performing their role. There's considerable public interest in ensuring that they don't continue in employment, or at least don't continue with performance targets, supervision, warnings, and so on.
Yep.
So yes, there is a particular public interest because of the coercive powers that police officers have. And these regulations are designed to protect them, but of course ensure that the public interest in having a competent, safe, non-corrupt police force is met. But similarly, that can be said in other environments too.
But were there no regulations, presumably the police officer could be deprived of office by whatever processes the
Yes.
Police force put in practice. So the public interest would be just as well catered for,
Yes.
if not more efficiently catered for, by allowing that. I ought to know the answer to this, Miss Monaghan. Can police officers complain of unfair dismissal?
Not general unfair dismissal, but whistleblowing.
Oh, you're going to come on to that. You
I am going to come on to it. Given the time, I'm going to deal with it briefly, but it
The way it
identifies...
works is because they're not employees, they can't claim unfair dismissal. They only have the limited rights given by Section 42 and an equivalent somewhere for whistleblowing.
Precisely.
Yep.
Precisely. And I'll come to that briefly because it reveals one of the great difficulties with having the decision in Heath in its application to whistleblowing.
But before these regulations, were these the first regulations?
No, they've gone back
So
to
they've been there forever, haven't they?
65, I think.
Yes, at least.
Even earlier than that, I'm told.
And from really almost time immemorial, chief constables were required to conduct really quite formal hearings,
Yes.
weren't they, of any complaints of police misconduct?
Yes. The trend has shifted, as you've seen from the written cases.
Yes. Well, I understand your argument that it has. Whether it's quite that or not, we'll have to decide. But I understand your argument that it has. But all I'm getting at is that the police have been historically treated differently because, I suspect, of the enormous public concern about police behaviour. In other words, that it be held to the highest standards.
Yes, I'm sure that's right.
It's not out of compassion for policemen or policewomen at all.
Well, it also confers basic workplace rights on police
do that as
officer.
well.
Fairness, which is a basic expected approach to the determination of workplace disputes. My Lord, it would be my submission that there has been greater formality historically. There is a particular need to ensure that the police are properly regulated in relation to their conduct because of their coercive powers. But it could be said of other professions too. As I say, I use social workers as an example, mental health nurses, mental health doctors that section patients. I mean, you have an AMP, an approved mental health professional, and a Section 12 doctor can section somebody and keep them in hospital for 28 days and thereafter if necessary. That is an extraordinarily coercive power, particularly in a context where no criminal act will have been done.
But the public interest dimension informs the nature of the proceeding, and in a sense, perhaps ironically, if the tribunal or if the panel is rightly concerned with the public interest in whether or not this person should continue to be a constable, that's not akin to a judicial proceeding because a judicial proceeding holds the ring between the competing interests of the individual concerned, whereas the proceeding before the panel partakes of a different consideration. It's a question of whether or not, as you have put it, it's right to assert that the employer, in inverted commas, the police authority, can properly assert that this person should no longer be a police officer.
Are you going to be taking us to judgments in Trapp and Mackey?
I was going to, yes.
That's
So if I just, I think I suspect your ladyship and your lordships have read Heath, but just flicking through it, I've dealt with paragraph 27. Paragraph 30, this is perhaps an obvious point, as indeed it's described, but just to highlight it, trite law that the fact that a tribunal or body may be required to act judicially in the sense of fairly doesn't itself make the functions judicial. And then over the page 539, procedure akin to that in civil or criminal courts, and this was the point I was just making in answer to a question by my Lord Hughes. You can see in the list of matters 1 to 12 identified under paragraph 35, there was much greater formality. In particular, for example, even in relation to the language, to the extent that it's material, but language like charges, accused, and so on. And the criminal burden of proof, for example. In domestic disciplinary procedures, ordinarily the standard will be civil. So we say the procedures here aren't akin to that in a civil court. We would say that in Heath, the Court of Appeal was wrong to conclude otherwise even there, but certainly not here. They are akin to ordinary domestic disciplinary proceedings that happen every day, hundreds of times a day, in the employment context. There was a claim under Article 6, in other words, that when I say a claim under Article 6, forgive me, Article 6 was relied upon to assert that because this tribunal or panel didn't meet the requirements of Article 6 as to independence and so on, it was couldn't properly be said to be Article 6 compliant and therefore attract the necessary judicial immunity. That didn't, the Court of Appeal was not persuaded by, bearing in mind that independence, they said, was not a critical component of a judicial tribunal. That's dealt with at paragraph 40. And then at paragraph 42, it was said that there's no binding determination of civil rights, relying on Trapp and Mackey, that is, that such was required. I've already indicated that it's my submission that the same is the same is true here. There is no binding determination of civil rights. There is an assertion of a civil right and a determination reached as to the right to assert that right in the context of domestic disciplinary proceedings.
So when we look at 44, which you needn't read out because you're under pressure of time, you don't agree with it?
No.
Yep.
And then balance of competing interests at paragraph 47. I won't read you this section of the judgment, but simply to observe, as no doubt your ladyship and your lordship have picked up, the Court of Appeal said that notwithstanding the importance of anti-discrimination rights, they didn't outweigh the competing interest in ensuring that there was absolute immunity in the case of a judicial tribunal. We say that, of course, or perhaps not of course, given the questions that have been asked, but we say that the right to non-discrimination may not outweigh every claim to judicial immunity. My right not to be discriminated against may not be so important as to outweigh this court's right to judicial immunity. But in the context of proceedings lower down, the balance is very different. And the lower down, the less a tribunal, a panel, a hearing looks like a judicial tribunal, panel or hearing, the greater the weight should be afforded other public policy considerations, like the fundamental right to non-discrimination, which Mr. Bowen will tell you is now a fundamental right at common law, but is in any event reflected in EU law, binding EU law for the purposes of this hearing. That is, sorry, but forgive me, for the purposes of the issues that arise in this hearing. There was an Article 6 claim. That is not just that Article 6 sheds light on the question whether or not this was a judicial tribunal, but also a contention that we make here too, that the judicial immunity in that context operated as a bar to accessing a court, a disproportionate bar, and therefore ought to be set aside. And at 70, whether or not, paragraph 70, I won't read it out loud, but you'll have seen that whether or not the judicial immunity acted so as to negative a civil right, that is, so that there was no right in consequence, or operated as a procedural bar, the importance of the right to judicial immunity outweighed that, 70-71, and so there was no violation of Article 6 in imposing it in the context of that case. Article 8, I needn't trouble you with. The Equal Treatment Directive was dealt with at Article 552, page 552, MS 552, paragraph 80. And in essence, again, the same conclusion reached in relation to the obligation to secure judicial control. We see that at 555. Paragraph 91. And at paragraph 93 in particular, no basis for saying that the directive should displace the absolute immunity. Relying again on Article 6, so analoguing EU law and convention law and holding that there was no violation of the Equal Treatment Directive. We say otherwise here. So that was the way Heath dealt with the matter. We say applying the Mackey guidelines, they came to the wrong conclusions. This was an ordinary domestic tribunal in a context where the workers concerned have coercive powers. But what was ultimately the function of the panel was to determine whether workplace standards were met, and if not, what sanction, if any, was applicable, just the sort of decision-making and hearings that go on all the time in a disciplinary context. As to Article 6 and the EU law, I'll deal with that after lunch. Just to deal with Trapp and Mackey, that's at tab 23 of the same volume, MS 597. This was a different case entirely. It concerned the status of a statutory inquiry established to determine whether a dismissal was reasonable. In other words, the employer had dismissed, and pursuant to various statutory powers, Secretary of State determined that an independent tribunal, it's a single person, but an independent tribunal would be identified for the purposes of assessing the reasonableness of that dismissal which had taken place. So even if it was right, and I needn't go any further than that, it is highly distinguishable. I'm just trying to think what sections I need to take you to.
Well, perhaps an important paragraph, I would suggest, page 380, between E and F, is perhaps the heart of Lord Diplock's reasoning, explaining that you have a petition by the aggrieved teacher to somebody neutral, the
Yes.
Secretary of State.
Yes.
The question which the Secretary of State then has to inquire into is whether the dismissal of the teacher was reasonably justified. Such a question partakes of the nature of a lease inter partes,
Precisely.
an issue between the dismissed teacher and the education authority.
Precisely.
It's rather
Different.
it's an obvious contrast with the present case.
Precisely, and it's a contrast that we make in our written case.
Well, it mirrors the proceeding before the Employment Tribunal.
Precisely. It's a statutory tribunal, and it is determining that dispute, which I was struggling to identify, but we have the employer in that case asserting a right to dismiss and dismissing. We then have an independent tribunal, indeed a statutory tribunal, that's significant, determining the legality, or at least the reasonableness, the justification for that dismissal. There is a real dispute between the parties, not an assertion of one party, a mere assertion of one party, resulting in an act that they consider lawful, as is the case in an ordinary workplace dismissal. At page 603, MS 603, I won't read it to you because it simply goes over the matters that have already been explored, but we see there the origins of the criteria picked up on, some of the factors picked up on in the later case of Heath, and bearing in mind certain matters that were specifically relevant to that inquiry at 603D onwards. You'll have noticed, for example, witnesses were compellable, evidence was taken on oath, etc. Much more like what we would recognise, I suggest respectfully, recognise as a judicial body, and costs awarded for the adversely treated employee, legal costs. So this is a completely different body. And it, with respect, it simply doesn't bear on the issues that call for consideration in this case. Two more domestic cases that I will deal with quickly. One is I've already alluded to. It's a case in which I was arguing the exact opposite, but happily lost. So,
But that wasn't your reaction at the time.
this is tab 18 of volume 2, MS 507. MS 507. This is concerned the question whether a decision of a disciplinary tribunal, a workplace-based disciplinary hearing, was binding, so that the principle of res judicata, estoppel, and abuse of process applied to prevent any further disciplinary proceedings in relation to the same matter. It was the Baby P case, the Peter Connolly case. And your ladyship and your lordships may recall that the social workers involved were subject to a disciplinary process. Warnings were administered. The Secretary of State directed that certain action be taken, further disciplinary process, and the social workers were dismissed. So the argument was that there was no right to take the second set of proceedings. The absence of any fresh evidence, they were barred by reason of principle of estoppel, res judicata in that case, it was said. If I can ask your ladyship, please, and your lordships to turn up MS 5156. This is Lord Justice Elias. He was, as it happens, the ex-president of the Employment Appeal Tribunal. I say that only because it doesn't mean he's right, of course, but it does mean he has a lot of experience of dealing with workplace disputes, so has a feel for how they work. First of all, paragraph 41, I won't take you to the whole, but just to notice that there's no doubt that some domestic tribunals set up by contractual agreement will constitute judicial bodies whose determinations will be judicial in the relevant sense. So in other words, the mere fact that something is recognised by law, in this case he's referring to contractual recognition, does not of itself make a body judicial. I think that we picked that up well enough from Heath and Trapp. And then at 43, paragraph 43, Ms Monaghan submits that a manager imposing a sanction under the simplified procedure was invested with authority to determine a dispute and therefore constituted a judicial tribunal. As I say, I'm happy to say I was entirely wrong about that for the purposes of the rule. This was so, notwithstanding the relatively informal nature of the process, she concedes there's no authority to support the proposition that internal employment disciplinary procedures will attract the operation of the doctrine, but neither is there one which denies it. Her case is that at least in circumstances where the procedures are contractual in origin, as they are here, the authorities are consistent with her submission that the doctrine applies. That was rejected. And paragraph 47, there's some discussion about the principle of res judicata that I needn't go into before that, but paragraph 47, in my judgment, it's wrong to describe the exercise of disciplinary power by the employer as a form of adjudication. The purpose of the procedure is not a determination of any issue which establishes the existence of a legal right, nor is it properly regarded as determining a dispute. In the employment context, the disciplinary power is conferred on the employer by reason of the hierarchical nature of the relationship. The purpose of the procedures is not to allow a body independent of the parties to determine a dispute between them, pausing there, compare Trapp. Typically, it is to enable the employer to inform himself whether the employer has acted in breach of contract or in some other inappropriate way, and to determine how that should be dealt with. It's true that sometimes, but not always, the procedures that have been the procedures will have been contractually agreed, but that does not, in my judgment, alter their basic functional purpose. Pausing there, my submission, the same can be said of the regulatory regime in the case of police. The fact that they have a formal legal context doesn't alter their basic purpose and function or status. Employer has a duty to act fairly, and procedures are designed to achieve that objective. Degree of formality of these procedures will vary enormously from employer to employer, but even where they provide a panoply of safeguards of a kind typically found in the adjudicative bodies, as is sometimes the case in the public sector in particular, that does not alter their basic functions, far removed from the process litigation or adjudication, which is the essence of where this doctrine bites. And refers to Matu, which really makes the same point, and I needn't trouble you any further with that. That's all I need to take from that case, emphasising the particular role, function, and therefore status of a disciplinary body, even in a context of great formality. Doesn't alter its basic purpose, function, and status. Doesn't attract all the rights that one would see, all the doctrines, doesn't attract all the doctrines of finality and so on that one would see ordinarily in a court. That's one last case on the general context, if I may, just to highlight the problems that Heath causes, because there is no doubt that Parliament has conferred specific rights on police constables, leaving aside the Equality Act, which properly analysed would be unenforceable if the misconduct hearings truly attracted judicial immunity. And this is apparent most clearly from Lake, tab 21, page MS 574. This was a whistleblowing case. And a whistleblowing case brought by a police officer. And if I can ask, please, your ladyship and your lordships to turn up MS 579. Paragraph 20 sets out the right. Paragraph 20. Section 94(1) provides that an employee has the right not to be unfairly dismissed by his employer. Section 103A provides an employee who is dismissed shall be regarded for the purpose of this part as unfairly dismissed if the reason, that's what's operating on the mind of the dismisser, or if more than one reason, the principal reason for the dismissal, is that the employee has made a protected disclosure. That, of course, on the face of it wouldn't cover police officers, but specific statutory provision was made, paragraph 23, the judgments. By Section 37(1) of the Police Reform Act, a new Section 43KA was included in the 1996 Act. It extended to persons who hold the office of constable, otherwise than under a contract of employment, the protection in Section 47B and 103A for our purposes of the 1996 Act. It provides that the constable should be treated as an employee employed by the Chief Officer of Police under a contract of employment.
For the purposes, is this right, of a whistleblowing claim for unfair dismissal?
Precisely.
So the mechanics are, although the effect's the same as Section 42, the mechanics are different.
Yes.
It gives him the right not to be unfairly dismissed.
Yes. I'm not. Your lordship is looking quizzical, and I'm not sure I'm understanding what is it.
I'm just wondering whether the difference of mechanics affects the outcome, but we'll see.
Okay. Well, not certainly not in my submission.
I understand that it makes a difference to the practical problem.
It makes a practical problem, and it makes a practical problem because, as we've seen, the dismisser, the person who decides to dismiss, are the members of the hearing panel, and it is the reason that a person has made a protected disclosure must operate on their mind because they are the dismissing body. Principal reason for the dismissal is that the employee has made a protected disclosure. The reason for dismissing the officer must be that they have made a protected disclosure, and that must operate on the mind of the persons dismissing him. Now, it seems impossible to reconcile that, in my submission, with Heath, Parliament having conferred a right. To enforce that right, it necessarily involves impugning the integrity. I don't mean that in a pejorative sense, but it means making a claim, putting more neutrally, making a claim against the members of the hearing panel. It's difficult to see how otherwise that claim can be asserted. One is making a claim, the dismisser is the chief constable, but one is making a claim that the reason for that, the reason is formulated in the minds of the panel, who would presumably be called to give evidence and cross-examined, was that he had made a protected disclosure.
But wait a minute, is the effect of 43KA, which I don't think we've got, to make the chief constable the dismisser?
No.
It isn't?
No. In fact, if you just find me that, I'll
that's good enough. Thank you.
Okay. Well, we'll certainly find it
It's
for
about
you.
time.
We'll certainly find it for you. It treats this as an employment relationship,
Yeah.
so that the right is engaged. But the mind of the dismissing officer or persons is what's material to the question whether the dismissal is unfair because it's by reason of a protected disclosure. To answer that question, necessarily questions would have to be asked of the body or persons making the decision to dismiss.
Leaving aside whistleblowing, presumably you would say that if you assume that dismissal by the disciplinary panel falls within the scope of Section 42, then it follows that Parliament must have intended, if you assume that there were judicial immunity, Parliament must have intended to override it.
Precisely. I mean, our next point is that if our next point is properly read, even if these panels would otherwise attract judicial immunity, that's displaced as a matter of ordinary constitutional law.
Yeah, because your point is they don't attract judicial immunity in the first place.
We say it doesn't attract judicial immunity, but and if it does, well, there we are. It's gone. It's history. Okay, my Lord, just for my Lord Hughes's note, 43KA is at Volume 5, MS 1172, tab 43.
Very much.
But wasn't it always history?
Sorry?
Wasn't it always history? Because didn't anti-discrimination provisions always, the sex discrimination, race discrimination, always apply throughout the shifting police conduct regulations? I think that's Mr. Bowen's point, isn't it?
Yep. It's always been there.
The question of it's being history, it's a question that it was always. It's
been there since 1968, and the police conduct regulations precede that. So I suppose there might have been a gap where it did, but it certainly didn't after the first Anti-Discrimination Acts addressed employment in 1968 and thereafter more fully in later enactments. There we are. It was always thus is probably the better answer. And it certainly is thus now. And then at paragraph 27, the Court of Appeal dealt with what in my submission is an obvious difficulty. Paragraph 27, in all submissions, Mr. Lissack for the respondents maintains the submission that the decision of the board cannot be impeached at the employment tribunal. That is, the persons who made the decision to dismiss. The customary immunity which attaches to judge, advocates and witnesses as confirmed in Heath is not challenged. So the impeachment in that sense doesn't arise. What the claimant seeks to do is to put to the employment tribunal the case which he had unsuccessfully put to the board. Well, pausing there, the case which the claimant seeks to put to the employment tribunal is that he has been unfairly dismissed by reason because, operating on the mind of the dismisser, he'd made a protected disclosure.
Well, actually, of course, in Lake's case, yes, that's right, but in Lake's case, it was the Chief Constable who dismissed him, wasn't it?
Yes, but...
been a non-binding decision of a panel.
Yes.
Earlier regulations, different system.
Yes, it was... No, so the Chief Constable was a review, but he didn't dismiss. No. So the Chief Constable reviewed the decision that had already been made to dismiss.
Yes. And upheld the sanction of dismissal.
Yes.
You say that wasn't him dismissing?
As I understand.
All right, maybe.
It's under the old procedures, not
Yes.
now. Under the old procedures, once a panel had made a decision, a person had the right to seek a review from the Chief Constable.
That's right, paragraph 6 of the
Paragraph
decision.
6.
Yeah.
They directed his dismissal.
Whereupon the Chief Constable reviewed it and either could uphold it or not as he wished, as I understand it.
Yes, but it's the dismissal, as I understand it, that's affected by the panel. In any event, even if, my Lord, even if that were wrong, that is the position now. it will be the panel who will dismiss in the face of unfair dismissal rights which attach to the decision to dismiss and which require a tribunal, an employment tribunal, to inquire into the mind of the dismissing officer. Why did you dismiss this person? You dismissed him because he'd made a protected disclosure. That requires an examination of the mind of the members of the panel. That is, it highlights the difficulties, the friction between the rights that Parliament sought to provide officers in the workplace and the approach of the courts, the Court of Appeal in particular, to the conferring of judicial immunity on what is essentially a disciplinary panel which may result in a dismissal, which is then justiciable in the employment tribunal. My Lord, my Lady, so in short, we say that judicial immunity doesn't apply for all the reasons we've given and set out in our written case. We emphasise the importance of undertaking a balancing exercise and the great weight that should be afforded to the principle of equality and the importance given to fundamental rights, which will be explored by Mr. Bowen. And I remind your ladyship and your lordship that the trend in relation to immunities has gone one way. That is to limit, reduce the scope. So we've seen barristers, not judges, but barristers in any event, now not protected by the immunity previously enjoyed, expert witnesses. There must be proper justification, whether that's a proportionality analysis, which we see informing the common law in the context of fundamental rights, or an ordinary balancing, weighing up exercise. Either way, the balance lies well in favour, we say, of concluding that this is not a judicial tribunal, not one that deprives police officers of the benefits of worker status.
Your appeal was to succeed, and your claim in the employment tribunal was to proceed, and you were to persuade the tribunal that the decision to dismiss your client was wrongly infected with discrimination. Where would that leave the dismissal, which was directed by the panel and upheld on appeal?
The dismissal would remain in place. There's no power to, in this context, in the context of discrimination law, there's no power to reinstate at the hands of a tribunal. They would award compensation.
So how could one reconcile an existing dismissal wrongly infected with discrimination and its subsistence?
The subsistence of what, my lord?
Of the dismissal. There's a wrong dismissal.
There's a wrong dismissal. The law provides a remedy and compensation for that wrong dismissal. It doesn't in the context of equality law, does elsewhere, but in the context of equality law, it does not provide the tribunal with the power to reinstate.
So it's an effective dismissal, but a statutory tort.
It's a statutory tort, compensation in the ordinary way for injury to feelings, as long as injury to feelings, compensation for injury to feelings, as well as loss of pay, calculated as with an ordinary tort, and declaratory relief. In some contexts, there are other remedies, but those are the two. The main one in practice is compensation. A person will get compensation for the harm, the injury to their feelings, aggravated damages perhaps in appropriate cases, and losses calculated as with any other tort.
So there's an inconsistency between the determination of the appeal tribunal, no relevant unfairness, appeal dismissed, and the employment tribunal coming along and saying, unfairness here, infecting dismissal.
Yes, because it's the employment tribunal that is determining the dispute. The lower tribunals, or rather disciplinary hearings, depending on how one describes them, are, as has been suggested, asserting from an employer's point of view their right to terminate the relationship because of a failure to meet workplace-based standards, whether they're set out in regulation or contract or otherwise. The dispute as to the legality of that arises in the context of an employment tribunal, or the High Court sometimes, as the case may be.
Thank you.
We've said as our second ground of appeal.
I'm sorry, Ms. Monaghan.
I'm sorry.
At some
I beg your pardon.
stage, no, I'm very conscious of time, and I've taken too long. But while we're on the judicial immunity point,
Yes.
have there been decisions about other disciplinary tribunals with statutory or indeed non-statutory setups, contractual or otherwise? I wasn't thinking so much of the Jockey Club, which I see you cited in one of the earlier cases, but what about GMC, accountants, etc.?
Yeah,
Are those judicial or not?
Yes. Sorry, in very large, the sort of disciplinary tribunals that perhaps you have in mind, the NMC, the GMC, they attract judicial immunity. They are they are independent tribunals.
They're independent tribunals.
They're independent tribunals. Not only do they have a panoply of statutory rights, they deal with matters such as continuing registration.
Yeah.
This is not about loss of a job, generally. It's about loss of professional status. And they're expert tribunals. And they're independent. So the Solicitors Disciplinary Tribunal, for
It's
example.
actually a good example, yes.
GMC.
But it will carry the loss of the job, but you say that isn't its principle.
No, and indeed that's a very significant distinction, as there is case law on this in Matty, which I didn't go to. The fact that a doctor had lost his job, he said, was to impede his opportunity to practice, and there it was in Article 6 territory. Court of Appeals said no, loss of a job might not be good for your reputation, but it doesn't affect your right to practice in a particular profession.
That's the other way around.
Yes. GMC, on the other hand, is quite different, and it's a statutorily constructed independent tribunal, much more like the sort of tribunals that one litigates in, and of course determines much more fundamental matters. And they're expert tribunals.
As you know, in paragraph 25 of his case, Mr. Linden cites 9 tribunals, each of which has been held to be quasi-judicial. You don't challenge that they have been held to be quasi-judicial, but you say they're different.
They're different. Mr. Kemp kindly did a note on some of them for me, but they're either complete. Things like the GMC are simply, we're in completely different territory here.
It's to do with your professional status and your right to practice your profession.
Precisely.
It's not to do with the particular job that you have.
Precisely. It's not about you haven't met your employer's workplace standards. You have not got the right to practice in this profession.
I understand that.
Yeah.
I understand the distinction, but I'm just exercising my mind about which side the police fall on. Because the police officer's position is primarily status. It's only employment by statutory exception for the 2 purposes that you've identified: whistleblowing and disability and discrimination.
Yes, but a police officer, of course, for some public controversy, can leave the Met Police Force today and join the Northumberland Police Force tomorrow.
Yes, I follow that.
And can be dismissed from the Metropolitan Police Force.
Theory be taken on elsewhere.
And indeed
More than
in
in
practice.
theory, yes.
And indeed in practice.
Yeah.
There are...
Yes, I see.
So we're looking at the position as it currently applied. There are, I think, changes in progress, but certainly the position is at the moment that you can you can walk out the Met Police and join the Northumberland Police on Monday. So we are in quite different territory. We're loss of a job not loss of an opportunity to practice in the area that you seek to practice a profession in.
Well, Miss Monaghan, that is a convenient moment, is it not?
It is. I'm sorry.
Lord Hughes has
I'm
brought
sorry.
you to the end of ground one.
Yes, but happily ground 2 is very quick, and 3 and 4 merge into 1, really. So I will keep to time, I promise.
Well, we'll look forward to hearing from you again at 2 o'clock. Court is now adjourned.